Good morning once again, ladies and gentlemen. Such a delight for me to introduce to you this distinguished panel dealing with session two of this important conference. I think the title of this session is Urgency, Communities, and Democracy. And it's designed in such a manner to further the debate we've had as the foundation in the morning. So with me on this panel is three professors, Professor Mary Ali, who I think most of us here are familiar with. A territory of influence in environmental issues is quite very wide. So we also have with me here, Chiara. I hope I pronounce your name very well. Otherwise, you pardon me. He's also a great scholar in our own right. And of course, we have another participant joining us, I think, online, from Professor Jim McAdam, who is also not a stranger in this field of climate change, particularly in relation to induced displacement. So I would give...
And Professor Rebecca Willis.
And of course, thank you so very much, Professor Rebecca Willis is also part of the panel. I think I'll hand over to Maria to start.
Okay, brilliant.
The floor is yours, yes.
Chiara and I are giving a joint presentation, and I'll kick off. And our presentation builds on this article published in the Journal of Law and Society. Chiara and I have worked on public participation together and separately for many, many years, and we've observed an increasing need to go back to basics, to explicitly support legal rights to participate in the face of disillusionment or even backlash against public participation, especially, we think, in the context of climate change. Today, I'm going to begin with a moment on the rule of law. Chiara will then turn to the challenges to participation at the moment and also to participation's continued importance, even and especially in a time of climate crisis. And then at the end, I'll come back briefly to the role of law in participation. So first, rule of law. We don't necessarily want to add participation to the laundry list of rule of law. We simply want to suggest that the legal protection of public involvement in the exercise of power belongs in our discussion of rule of law. Rule of law, on most even modest approaches, encompasses constraints on the exercise of power. These constraints are often found in substantive legal obligations, in our case around climate, and might, for example, take the form of a reminder that even the most powerful must comply with the law, no exceptions. Constraints on power at this most basic level are crucial for progress to net zero, and we're in constant receipt, Tom Burke mentioned it earlier, we're in constant receipt of reminders that we can't be complacent about even these most basic issues. But Chiara and I are thinking about perhaps more mundane questions around the day-to-day exercise of power within the administration. Rule of law in the administrative state is largely concerned with procedural matters, obligations to consider evidence, to provide legitimate processes, to provide reasons, for example. These apparently banal procedural constraints can nevertheless require or encourage those with power to attend to the individuals and communities affected by their decisions, including and perhaps especially when such attentiveness is inconvenient. Now, rule of law as constraint, and this links into Jeff's paper earlier, Jeff's introduction earlier, rule of law as constraint might be a double-edged sword in climate terms. Constraint on extracting oil or expanding airports, yes, but also on decisions to ration fossil fuel or on building wind farms. Two things on that. First, administrative legitimacy too often focuses on economic interests, on developers and producers, on those seeking environmental permits and licenses, as if they are the only ones affected by a decision. Thinking about public participation requires us to attend to alternative perspectives, to amplify the voice of environmental groups and ordinary citizens. Second on this double-edged sword, rule of law and its links with participation goes beyond constraints. So like Jeff, we might think about Kriegier's approach to tempering rather than constraining, so that rule of law might strengthen the state in certain respects. Because the last thing we need in a climate crisis is a weak state or a weak broader polity, because power in private hands is also risky. So looking beyond economic interests, participation can provide different perspectives on state action and a different potential for state action. It takes us beyond a purely formal approach to rule of law. The link, of course, between our procedural issues and substantive issues is important. And I think it's worth saying that a set of institutions that points towards climate justice is very likely to include a right to participate in decisions that shape our world. I'm passing over to Chiara now.
Thank you.
Thank you. Thank you, Maria. I will now focus on the challenges of participation and on the reasons why participation matters, even and especially in the crisis. The climate crisis puts participatory constraints on power under unprecedented pressure, and this pressure comes from different directions. Criticisms of democracy's ability to deliver good and effective decisions are recurrent. Democracies are slow, struggle with long-term, and are vulnerable to power and special interests. The territorial and temporal horizons sit uneasily with the scale of global crisis. These critiques often brew within the complex relationship between technocracy and populism, which constitute the context of the pressure on participation. The climate emergency framing builds on these failures and reinforces doubts about democracy's credentials. But we are concerned that the climate emergency narrative leaves little or no time for burdensome procedures, including participatory procedures. As a result of this framing, the climate crisis gives fresh appeal for technocratic responses, as we explore in our article. In a time of crisis, a more technocratic and less inclusive approach is seen by some as a way to overcome democracy's failures. At the heart of technocracy is the idea that all problems are technical problems with technical solutions that can be revealed by experts. And so participation is not helpful, welcome, or no longer possible. And perhaps counterintuitively, participatory constraints on power are equally under pressure from populism or from politics that tends towards populism. Technocrats and populists share a resistance to procedural constraints. For technocrats, procedures are a distraction from what Mike Hume calls hitting the carbon numbers. And for populists, because the will of the people is already clear and uniform, outputs are the focus, and legally protective rights get in the way. In our article, we argue that this rejection of process contributes to the silent erosion of legal rights to participate. And this poses severe rule of law questions. When the necessity of a participatory process is doubted, the fabric of the rule of law collapses. This rejection of process from the emergency narrative, from the technocrats, or from the populists combines and accentuates the familiar failures and flaws of participation. And of course, participation is not easy. Some well-known practical barriers, such as time, expertise and resources, inequalities in power and access, prevent effective participation, even if opportunity exists in principle. But despite the understandable critiques to participation, some of which we share, Maria and I think that the climate crisis makes the need for participation even more prominent. In a time of crisis, the inclusion of ordinary people and broader civil society in decision-making must be strongly defended. So technocracy is to be resisted. But let me be clear. Questioning technocracy is not to resist science, expertise, or knowledge. On the contrary, they are crucial. But we resist the argument, hope, and expectation that experts can lead us through the climate crisis. All that we have learned about expertise and values associated with wide public participation over recent decades continues to apply. There are choices around how to respond, and even in a crisis, the value of participation cannot be dismissed. Public participation matters, both because we have a legal right to be involved in decisions about our world, and because the fragmentation of knowledge and information means that good decisions demand diverse inputs. Our defense of participation focuses on the process. Even if participation fails to meet the ideals of democracy and environmental protection, participatory modes of decision-making are part of the democratic process, and they constitute the enabling environment of the rule of law. There is a substantive value in including otherwise marginalized concerns, including by rights of participation for environmental groups, even if some of these will pursue technical advocacy and lobby for urgent and measurable outcomes. Participation is necessary to complement expertise. Technocratic approaches face obvious practical questions on which broader input would be helpful and proper. Somebody needs to set the direction of travel with more or less detail. And so the aims of the experts need to be publicly defined and in an iterative way so that the objectives and responses can be challenged and refined. In the climate crisis, constraints on power cut both ways, against rapid action to mitigate and adapt, and against damaging activities, as Maria and Jeff mentioned. But public participation is not just the constraint on action, though. It can also be a demand for more and better action. Public participation matters no less than it always has, and participatory rights are a crucial part of democratic decision-making, even in a time of crisis. And I pass it on to Maria now to discuss the role of law in this space.
Okay, so Chiara and I think that law has a big and rather underexplored role in making participation work. A few examples from a potentially very long list. Law will frequently determine how much time there is for learning, exchange, revision of views. There might be minimum standards for reaching so-called hard-to-reach communities, or on accessibility of venues, notice periods for meetings perhaps. Access to expertise, access to training. Law can influence who is included, making space only for identified participants or for anyone who turns up. Law might explicitly identify communities, for example, environmental interest groups, the local community, or why not, people far away in time or in space might be legitimate participants in a process. And what about the consequence of participation? This doesn't mean granting participants a veto or a vote. It might mean, though, being required to explain decisions in terms of public interests and in terms that on reflection make sense to interlocutors. That's a key element of deliberation in theory and in practice, and it's something that could be supported through legal obligation. An obligation, for example, to explain more carefully at the outset of a participatory process what is open for debate and what and why and how and by whom has been closed by prior decisions reduces disillusionment of participants, but it also, importantly, implies that the ways that decisions fit together must be at least capable of explanation. And we also, of course, need to address the legitimacy of those earlier decisions, which is a really big and difficult question here. These and other concerns are why putting participation on a rule of law laundry list doesn't take us very far at all. The detail and the context matters. And that brings us to our final point. And this is perhaps, again, going back to Tom's point and Bersha's. Rule of law isn't just about law and lawyers. These procedural protections just don't work in the absence of a strong civil society and a certain political salience for climate change. And yet the legal protection of process can, in a virtuous circle, it has the capacity to reinforce those other values. The final thing we'll say is that the economically powerful will always, or nearly always, be able to participate in decisions that affect their interests. And economic interests are always, or nearly always, taken into account. Constraining or tempering that power, that private power, is central to climate justice, and we think that that means empowering alternative voices. Thank you, Ademola.
Thank you so very much, Chiara and Maria, for your thought-provoking and stimulating thoughts on participation, which I think resonates very well with the challenges that vulnerable populations often face in the field, particularly in Africa, where their voices are often on the low profile. They are hardly heard in matters affecting their interest. So thank you so much again. I want to now turn to, I think, Jane. Makedamu is on the online. Over to you.
Thank you very much. It's an absolute pleasure to join you. And I'm coming to you from the future. It's about 8 o'clock my time, and I can tell you your conference today is fabulous. I've sat through it all, and it goes really well. Before I begin, I'd like to acknowledge the traditional owners of the land on which I am, the Darramurrugal people, and pay my respects to their elders, past and present. The paper that I'd like to present today explores how international law and policy can harness the sense of urgency that was generated by COVID-19 for the longer-term climate crisis, especially when it comes to protecting people who are displaced in the context of climate change and disasters. And what I'm presenting today draws on work that I've done as part of a longer project, or a more comprehensive project, with Professor Michelle Foster and Professor Hélène Lambert. And the particular paper I'm presenting draws on something that we published last year in the UNSW Law Journal. Over the past 2 years, the pandemic has been described repeatedly as something unprecedented that's necessitated emergency measures that would ordinarily be unacceptable. So by being framed as a crisis, its exceptionality justified special restrictions and exclusion. And perhaps one of the most unparalleled and pervasive responses was worldwide border closures and travel restrictions. These curtail people's movement across the globe, creating inconvenience for many, but potentially life-threatening risks for would-be refugees, for example. The mobility challenges associated with COVID-19 sound an alarm bell for a different context. Last year, around 31 million people were displaced within their own countries as a consequence of disasters. That was 3 times as many people as were displaced internally by conflict. That was a record high, and it's likely to grow. And while we don't yet have good data on how many people cross international borders, because of the impacts of disasters and climate change, partly because there aren't formal visa categories to account for who is on the move, partly because there's often a time lag between initial displacement and subsequent movement elsewhere. But it's likely that cross-border movement will increase too, particularly if people can't find safety and security in their own countries. Without more predictable, protection-oriented measures in place, there's a risk that these people too will be trapped detained, or turned back. While some might qualify for international protection as refugees or on human rights grounds, many won't. And because international law doesn't provide pathways for people to move in anticipation of future harm, because migration laws are the domain of each individual country, there is some evidence that in some regions people can successfully utilise existing migration visas to move out of harm's way in advance. But in many other parts of the world, those options simply don't exist, particularly for those who find themselves in very vulnerable circumstances. As we know, a crisis is often posited as a one-off event. But of course, a crisis can encompass slower processes of change or deterioration as well. Understanding this is important because it helps lift our gaze beyond the here and now to contemplate legal and policy responses over the longer term. How an issue is framed matters because it can determine how a phenomenon is understood and responded to, both in a normative and a practical sense. If we think about crisis in an extended time frame, we can identify interventions now that could avert future shocks. So how can international law and policy harness the sense of urgency that was generated by COVID for the longer term climate crisis, without resorting to the familiar emergency mechanisms of reactive, short-term, restrictive and exceptional measures? Many of the measures that have been taken during the pandemic are relevant to preparing for the impacts of climate change. Things like the need to identify vulnerable populations, to assess the capacity of public systems to develop and invest in preparedness measures, and to emphasise community resilience and equity. But whereas COVID resulted in unprecedented measures of containment, the impacts of climate change are more likely to contribute to widespread displacement. As I mentioned, existing international protection measures really just offer an incomplete and imperfect solution here. In addition to the points I made just before, there are other reasons for this, including that some of the impacts of climate change will take years to manifest at a sufficiently harmful level to satisfy the requisite thresholds in international refugee and international human rights law. So the challenge for international lawyers and for international law itself is whether those bodies of law can evolve dynamically to offer solutions, as they have done historically as living instruments of protection. And certainly as understandings of the nature of mobility in the climate context have improved, our analysis of the capacity of those frameworks to respond has become far more nuanced. That said, approaching displacement solely in light of existing protection frameworks necessarily constrains our thinking, both conceptually and pragmatically. Towards the end of 2019, the UN Human Rights Committee accepted in principle that it is unlawful for states to send people to places where the impacts of climate change expose them to life-threatening risks or to cruel, inhuman or degrading treatment. In the matter at hand, though, which concerned a man from Kiribati who had sought protection in New Zealand, the evidence was said that the evidence did not establish that that gentleman faced a risk of an imminent or likely risk of arbitrary deprivation of life upon return to Kiribati. And this was despite the committee's acknowledgement that sea level rise was likely to render the country of Kiribati uninhabitable, potentially within 10 to 15 years. At the present time, though, the committee said there wasn't enough evidence to show that he would be unable to grow food or access drinking water or would face other life-threatening environmental conditions, nor that the government of Kiribati had failed to take steps to provide for the basic necessities of life in order to meet the positive obligation to fulfil the author's right to life. The committee did recognise, though, that conditions in Kiribati could become incompatible with the right to life with dignity before the risk itself was realised, thus tacitly acknowledging that people shouldn't have to wait until their lives are imminently threatened before they're eligible for protection. but the committee didn't provide guidance as to when such a point of incompatibility might be reached. Echoing the reasoning of the New Zealand tribunal and courts where the claim had originated, the Human Rights Committee essentially felt that the climate-related harms were insufficiently present for protection to be forthcoming now, partly because of the potential for intervening adaptive measures. So in essence, this means that the longer the future timeframe, the less predictive certainty there is, and the more speculative the risk assessment becomes because of the potential for mitigation, adaptation, and other risk-reducing actions. As I and others have noted elsewhere, though, speculation about what might happen in the future is a central component of determining refugee status, for example. So in refugee law, there can be a less than 10% chance of harm actually materialising, provided that the risk is itself plausible and reasonable. The crucial factor is the assessment of the intensity, severity, and nature of future harm, based on its foreseeability in light of the individual circumstances. And this is particularly prescient, I think, when one considers the Intergovernmental Panel on Climate Change's assessments of the likelihood of certain climate impacts occurring, some of which are predicted as virtually certain, so 99 to 100% chance of happening. All of this, I think, underscores the need for proactive policies to help build resilience within affected communities and to provide lawful opportunities for movement. While the current rate of global warming means some displacement now is effectively baked in, it's inevitable, the scale of that displacement and the attendant economic, social, and human costs could be radically reduced if strategic measures were taken now. A World Bank report posits that robust mitigation and adaptation measures could cut global internal displacement by almost two-thirds by the middle of this century. And in addition, disaster risk reduction and management, adaptation measures, increased opportunities for lawful migration, more systematic humanitarian responses to displacement, and selective planned relocations could help to avert future displacement and to let people make real and their own choices about whether they want to stay in their homes or move elsewhere. The climate crisis is an unfolding process, and interventions must be contemplated over longer timeframes with new combinations of institutional actors, partnerships, and sustainable funding models. The challenge, I think, lies in generating support for policy and legal change now so as to avert devastating consequences in the future, heeding the advice of scientific and other experts. Whereas with COVID, the consequences of inaction can be seen relatively quickly, for instance, as hospitals become overwhelmed with patients infected just a few weeks earlier. With climate change, it's going to take decades to see the full extent of the damage, although of course we're getting far too many snapshots already as to what it's going to look like. On the one hand, this longer time frame offers an opportunity for greater international cooperation towards a coherent response, far more so than emergency and often exclusionary measures allow. On the other hand, though, it may and often does mean that the crisis is perceived as a problem of the future alone, rather than one that's already having far-reaching human rights consequences. Thank you very much.
Yeah, thanks. Thank you so much, Jane, for that interesting presentation, particularly looking at what is happening at the international level and the possibilities that COVID offer, climate change for some lessons which are very useful. I will now hand over to, I think, Rebecca Wills. The floor is yours.
Thank you. I'm really pleased to be part of this panel and part of this conference. I am not a lawyer, but for quite a few years now, I've looked on with admiration at the various climate-themed cases hitting courts around the world. The gender case in the Netherlands, I think, was the first one that really caught my attention. And more recently, I worked very closely on the public inquiry, which is a legal process on the new coal mine that's been proposed in Cumbria, just down the road from me. And it was fascinating to actually sort of get behind the scenes of a legal case. So my appetite has been thoroughly whetted. I want to talk today about the link between the rule of law and democracy, which is my research obsession. I'm just going to share my screen so I can show you some slides. I think it's really important to start with an acknowledgement that we are still going in the wrong direction globally on emissions. And there was a review of this published last year. Why haven't we bent the emissions curve? And I've put there the list of reasons that this review came up with about why we haven't bent the emissions curve. And you can see that, I mean, there are things in there around technology, the energy supply system and so on, but you can also see there some really crunchy legal and political questions around climate governance, around vested interests of the fossil fuel industry, around finance, and around sort of social imaginaries and lifestyles. So we know technically that we can do this, right? And we know that the challenges are political and social. And so democracy, and this was echoed by Maria and Chiara, democracy is now under scrutiny because democracies, well, no country, but not even democracies have actually managed to yet come up with a commensurate response to the climate crisis. And so we've had these views put most explicitly, I think, by James Lovelock, the earth scientist, that climate change is such an issue, such a serious issue, as severe as war, that maybe we need to put democracy on hold. We also have, I think, a sort of implicit anti-democracy stance by, well, not anti-democracy, but maybe dismissal of democracy by by people who espouse the idea of planetary boundaries, which maybe is a sort of governance by technocracy approach, the idea that scientists should set boundaries within which democracy works. And I see this echoed all the time in my work with the climate policy community. I don't think there's any explicit anti-democracy there, but I think there's not sufficient understanding of the role of democracy in the climate crisis. But maybe they have a point because, again, as Maria and Chiara outlined, democracies are short-sighted. They run to, 5-year maximum democratic cycles, electoral cycles. It's well documented that democracies tend to make poor use of expertise. And it's also well documented that democracies are to a certain extent captured by high carbon economic interests. And these are all problems that are making it harder to tackle climate change. I would argue, though, that contrary to James Lovelock's position, the answer to the failings of democracy are not less democracy, but more democracy. And I think the best way of explaining this is going right back to some of the foundings of democracy and democratic theory. And on the one side here, you have the democratic system of ancient Greece, essentially a direct democracy, where if you wanted to take part, you could go to the town square and raise your hand. Now, of course, in Athenian democracy, you had to be a man, and you had to be a free man, for that matter, to participate. So I'm not holding this up as an ideal by any means, but the point was that everyone who was included in that democracy got their say in a very direct way, and there was that sort of sense of participation and debate. And then on the other side, you can see Edmund Burke, 19th century British politician, who took representative democracy to the other extreme, if you like. This idea that once your leaders are elected, they should be free to do what they want, and that you place your trust in that individual, and they then basically act on your behalf. So I would argue that obviously the Athenian model is, unworkable in a democracy of, say, 70 million like the UK, but that we've gone far too much to the other extreme, that we have prioritized a representative democracy based on competition between parties, based on, a pretty minimal role for voters, putting a cross in a box once every 5 years, and that we haven't really nurtured the conditions we need for a healthy democracy that could tackle climate change. And so I'm particularly interested in the role of deliberative democrats like Jane Mansbridge, who's really led the way on this, who want to focus in on the conditions under which democracy functions, who want to get away from the sort of thin concept of the basics of democracy as voting and electoral competition, and look much more at what creates a healthy democratic society. So what does that mean for climate change? Well, the basic democratic idea is the social contract, isn't it? It's this idea that we as individuals give up a certain amount of freedom or autonomy in return for collective solutions, collective support that we couldn't access as an individual. So that's the point of government at its very basic level. It's to keep you safe, to provide public goods that you can't provide for yourself. And so it's basically a negotiation between citizens and state. And I think that it's really helpful to think of our response to climate change as a social contract, because obviously we can't solve climate change as individuals. We have a role to play, of course, but there are all kinds of ways in which we need the state support for that, not least of all lawmaking, of course. We need laws and structures, infrastructure, institutions that can provide conditions under which we play our role as individuals. So this can be, even at a very practical level. So, we know the, how significant transport emissions are. We might want to drive our cars less. But if we live in a remote rural area with terrible bus services, we don't have that choice, and we rely on the state to put the infrastructure and legislation in place. Even if they don't own the buses or provide the buses themselves, they need to provide the institutions which allow a public transport system to work. And so I think by focusing on that social contract, we can think about how that conversation works, how citizens talk to government and how government talks to citizens. And this is where deliberation comes in, because the whole thrust of deliberation is that it should be this reciprocal discussion, which is, in this definition, inclusive, non-coercive, which actually doesn't claim that individual preferences are somehow preset, as an economist might assume, but in fact says that individual preferences can be moulded and can shape public policy and be shaped by public policy, that it is this conversation between citizen and state. It is, if you like, a reasoned compromise. And I think it was really interesting hearing Maria and Chiara reflecting on the importance of process, because I think that deliberative democracy is partly legitimated through process, through giving people the opportunity to be involved, and is partly legitimated through outcome. Because I think particularly now we've reached sort of absolute crunch point for emissions reduction, and we are looking at reductions in areas like transport, in food and land use, in what our homes look like and how they're heated, we need to get really fine-grained intelligence about how people live their lives, and how we can work with people to allow them to live their lives with less impact. And so through deliberation, you get that really fine-grained intelligence from citizens, that social intelligence hopefully leads to better policy outcomes. And so what all this adds up to me is an answer to some of the problems that democracies face in terms of timescales, because if you take this more considered approach, you can think longer term. And I think Jane's talk for me really brought out the importance of timescales. Better decisions on how evidence is used, because a core part of deliberation is access to really good evidence, and experts and evidence providers very much working hand in hand with citizens to share knowledge and experience. It also, in theory, could counter some of those problems that that review I mentioned highlighted in terms of high carbon economic interests, because it privileges citizens' views and puts them centre stage. So you no longer have to have, I mean, crudely, you no longer have so much money to access the political system. Money doesn't talk as loudly if you're more deliberative. So all this sounds absolutely brilliant and, possibly way too idealistic, but I've seen it happen in practice. So I was part of this incredible experiment that we did in the UK, starting just before COVID, Climate Assembly UK. And this is where we got 108 people who represented the UK as a whole in their demographics in terms of age, socioeconomic background, ethnicity, gender, and so on. And we spent 8 days with them deliberating on how the UK should reach its target of net zero by 2050. And I can't go through the full recommendations of the Assembly, of course, but the headline is this, that those 108 people came up with really sensible, implementable, and ambitious recommendations for how the UK should reach its target. It was probably a bit different from what some environmental groupings and business groupings would have wanted, but it added up to a coherent policy package. Importantly as well, those citizens came up with a set of principles to guide climate policy, including things like fairness, which they defined for themselves, and leadership, particularly from government. And so, the bottom line for Climate Assembly UK for me is that it worked, that doing this very deliberative experiment actually worked. And there was quite a lot of skepticism that, ordinary people would not be able to tackle these issues because they're too complex, or, that people are too selfish or whatever. But, this picture of this hotel room in Birmingham where we worked just proves to me that people can have sensible conversations and reach good conclusions and provide access to social intelligence which would not otherwise be available for policymakers. There are lots and lots of examples of this now in the climate space, including local citizens' juries, and I think the jury language is interesting. But they have tended to be sort of one-off big bang events. And so my work now focuses on how you embed deliberative methods in the process of making policy, making laws, and what that might look like. And I think I'm just going to end with a few thoughts on what that could look like. Firstly, I think it's important to acknowledge that we need deliberation about the very big scale, the very big problem of climate change, the fact that it's the biggest threat we face, the huge threat it presents to both to humans and to nature. So we absolutely need deliberation on that big issue. But we also need deliberation to contribute to what you might call small problems. They're not small, but they're smaller than the big problems. So we are embarking on some work with the UK's Climate Change Committee, doing some deliberation with the Citizens Panel on how to decarbonise home heating. One tiny part of that overall big problem, but a really crucial one to get right. I think it's possible as well to use deliberation to counter high carbon interests, and we've seen this work very effectively with legal cases as well. And you know, I think there's been a reluctance to do this, maybe because when you talk about countering high carbon interests, that immediately sounds political. That's true, but the evidence is there that they are standing in the way, and so we need to work out ways to break that stalemate. As I've said, we can use deliberative processes to get better use of expertise, to get a proper dialogue going between experts and citizens. But there are real challenges around scaling up these processes, and I think that the biggest challenge is in implementing findings, because you can create a sort of perfect democratic condition within something like Climate Assembly UK, but then its findings are thrust back into the normal process of governance and politics, and we shouldn't expect something like a Citizens Assembly to sort of miraculously solve all these problems that climate policy making has been beset by. So I'm going to end with some very inexpert thoughts on what this means for climate. I would hope that laws made that laws and policy and governance made through deliberation would be stronger because they have explicitly involved deliberation and directly involved citizens. And I also think that it's this idea of a social contract, and it you know, has some legal overtones to it, doesn't it? That, you know, whether there's a case that a legal contract is stronger if it's also a social contract, if it is also participatory in design. And lastly, you know, the language of citizens' juries has been used a lot in the deliberative space, and I think that the jury language is no accident. That we want to feel that we have been judged or governed by our peers, and to a certain extent, this is a sort of beginning of an answer to populism. That, you know, that the trust me, I'm an expert thing is clearly not working in the political domain now, and that if we develop more of a sense that policy and governance is something that ordinary people do, then maybe that's some of the answer to our current political malaise. So thank you very much for including me in this, and I'm fascinated to hear from the more legally qualified people on the panel what their thoughts and responses might be.
Yeah, thank you, Rebecca, for that stimulating presentation. I must say you play on my emotion initially when you said democracy should be put on hold, quoting that person. And I started wondering, then what do we do with the opposite, which is despotism? If we say, the alternative is despotism, and that in itself is not acceptable. If we say democracy is short-sighted, then it means that dictatorship, what do we say about it? It lacks sight, you know, and no soul, no heart, and I don't think that is what we want in climate change discourse. But then you move from the provocative to the curative by saying, looking at the values, you know, embedded in democracy that can be used to, you know, tackle the situation. So it's more democracy, like you say, making it better, not resorting to the opposite, which in some part of the world is totally, the problem as we speak. So thank you once again for that.